Along with the federal law, there are a number of states, including Indiana, with a Religious Freedom Restoration Act law in place. Take a look. These 20 states all have similar laws. So what makes Indiana's different from them? Earlier today, I sat down with Dr. Nancy Marcus, a law professor at Indiana Tech, to have her explain that very question. Dr. Marcus, Indiana's legislation, RFRA legislation, has ignited uproar across the country. Now, lawmakers state it is similar to 19 other states. However, it's not. Can you please explain the differences?
Sure. There are differences between our RFRA and previous states. Now, whether they're technical differences that really make a substantive difference or not remains to be seen. Here's what the differences are. First, and to understand the RFRA statutes, you have to understand the court decisions that these statutes came out of.
Okay.
One of the differences in Indiana's RFRA is that it specifies that corporations have religious freedom too. Well, where did they get that from? The Hobby Lobby decision from the Supreme Court. So the Supreme Court decided in Hobby Lobby that corporations basically have some religious protections too under the federal RFRA. So this is basically mirroring that. The other technical difference is a bit more interesting. It specifies that you can basically bring a RFRA claim if you believe that your religious freedom has been violated, even if there's no government involved in the lawsuit. It's a minor thing, it's a technical thing, but it's interesting because that specifically allows potentially businesses to use this as a defense against public accommodations laws. So for example, in Fort Wayne and Indianapolis, there are ordinances that protect LGBT individuals against sexual orientation discrimination.
Okay.
So in theory, this Indiana RFRA would allow them to use RFRA as a shield against that ordinance.
So it would supersede.
Perhaps, but maybe not, because again, in the Supreme Court Hobby Lobby decision, the Supreme Court actually said, look, this federal RFRA can't be used to justify discrimination. But then in the next sentence, the court went on to say, because there's a compelling government interest in preventing racial discrimination. So the question is, how broadly will that be extended? Does that also apply to sexual orientation discrimination? We don't know yet how the courts are going to rule. So a lot of this remains to be seen how the courts are going to be interpreted.
As it is written right now,
yes.
Could it discriminate?
It certainly could be used that way, yes. Will the courts allow it to be used that way? We don't know. But unfortunately, if you're waiting to test it out until it gets to court, it's going to be too late for some people. In other words, the harm will have already been done. So your worst case scenario is a situation, for example, where you have a child who needs medical care.
Okay.
She has lesbian parents. The health care worker finds that objectionable and raises some kind of religious freedom exception to not having to treat that child. Do we want to wait until that child is harmed before that's tested in court? And unfortunately, we're going to have to wait unless we protect people through strengthened civil rights legislation.
Again, that was Dr. Nancy Marcus from Indiana Tech.